Kenneth Mendez. Court is calling 2025 CR 014219, State versus Kenneth Renee Mendez. Can our parties announce?
Martin Gedda, attorney for Kenneth Mendez.
And are you Mr. Mendez?
Okay,
I'm sorry?
I'm good. How about yourself, Jim?
I'm doing great, but are you Kenneth Mendez?
Oh, yes, I'm sorry. I said, how am I doing?
Well, I'm glad you're doing great. Probation, this is an application. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mendez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Mendez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Mendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied at naturalization and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is asking that your punishment be assessed at 3 years in the prison. There's a $1,000 fine. They're opposed to your application for deferred adjudication and community supervision. They're taking in consideration 2025 CR 014218. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled.
This is where things get intense. The judge isn't just deciding guilt, she's controlling the terms of this man's entire future. And here's the twist. Freedom might come with a condition he never expected. So let me ask you, what would you choose if both options came with a serious cost?
Upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then for the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor, sheet offers sleep to give it 1 month.
Any objection?
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Your Honor, we can't waive a PSI.
All right. Anything you wish to say on behalf of your client?
Your Honor, he is 39 years old. And first, I'd say he does accept responsibility for this. This is not a situation where he's been trying to hide behind any excuses. He knows he made some bad choices. And his exact words to me were, he's never really, well, if you look at his criminal history, he's never asked for probation. There was some questions about one particular case, a forgery case back in 2012. In the criminal history, it indicated that he had a reputation. But he was telling me that he actually never was released from Bexar County custody. He wound up getting revoked several months after he was placed on the deferred adjudication. But he wanted to make sure, he was telling me to look that up because he said that he has never before asked for probation, but he's at a point in his life as 39-year-old man where he understands he's at a crossroads.
Mhm.
And what he also understands is that he just does not want to have to deal with this lifestyle. He's hoping that with all respect, that he would give him the opportunity to show that he can be successful on deferred adjudication. He's open to treatment. He wants to go to lifetime recovery. He's trying to, as best he can, make plans for himself. He's been on the waiting list actually since he's been in custody for several treatment programs here. Unfortunately, he just hasn't been able to get into those, but he has been asking about them. And I do believe he would be a good candidate for the deferred adjudication, especially at this point in his life when he desires some rehabilitation.
All right, State.
Your Honor, based on the criminal history of Mr. Mendez, I don't feel that he is proper. He has several convictions. He has 2 less than a gram cases where he did respectively, he got a 1244 under one and then did a trip for TDC. He also has that forgery defense mentioned, which is a state jail as well as 2 misdemeanors. Regarding this statement of him never being released, I do see here on that forgery case, he did get an MTR and it included some technicals in the new number 1. And I can confirm whether he was in that released under that case as well, just so that it is. Regarding that case, they do show that he was released on 9/11.
Quick pause. This is a huge moment that most people overlook. By pleading guilty, he's giving up his right to a trial, to challenge evidence, and even to stay silent. This is what's called a knowing and voluntary plea. And if it's not done properly, the whole case can fall apart on appeal. So here's the question. Do you think defendants really understand what they're giving up in moments like this?
I'm sorry, 11/6/2014.
All right, when's the last time you had employment?
So it was a Walmart. I don't recall what year. It might have been that year that I picked up that felony, the state judge.
Okay. And when did you start using? How old were you?
I had been I started off with marijuana at a young age.
No. When? When? WHEN, when did you start using?
The methamphetamine.
No, any drug. What's the first time you remember using drugs? How old were you?
I was 17.
All right. And then the meth and everything else, when did you start using that?
And that came later on in life, around my mid to late 20s.
All right. And who is Miss Rankin to you?
She's my girlfriend.
And is she using too?
No, ma'am, she's not. She's my inspiration to stop using. She at one point was suicidal, jumped off the bridge, and ever since then she had changed her life around, and she's not using. I mean, as long as I've been locked up, she's been telling me that she's not using, and I believe her.
But here's the thing, we don't know that. I don't know that. You don't know that.
That's right.
All right, so what I'm gonna do for now, well, I'm gonna give you a choice, first of all.
Okay.
1, I'll find you guilty and I'll place you on probation. Or 2, I'll find you guilty and send you to prison. Those are your two choices. But I don't think you should be having contact, or at least in-person contact, with Miss Rankin at this time, because usually people, but I don't think you should be having contact, or at least in-person contact, with Miss Rankin at this time, because usually people that are in the throes of their addiction, when a person is with them, especially if it's the girlfriend or whatever is going on, they're in the throes of their addiction as well. And the fact that you're telling me she's told you she's not using and you believe her tells me that at some point in her life with you, she's been using as well.
Yes, ma'am.
All right. So there's not going to be any in-person contact with Miss Rankin.
Yes, ma'am.
So do you want probation?
Yes, ma'am.
All right. All right, this is what the court is going to do. The court is finding you guilty. The court will sentence you to 3 years in the prison, suspended and probated for 3 years. There's to be regular reporting by Zoom or in person, regular random UA. In custody, there's to be a referral to felony drug court counsel. They'll be able to see him before the week is out. There's to be a TAP evaluation. That's going to be out of custody. Follow all recommendations. There's to be no residing in households with minors, no unsupervised contact with minors, proof of employment within 45 days of release. There's to be no employment as a home health care provider with minors. Field visits 1 time per month until further notice. Take in consideration 2025 CR 014218. There's to be 200 hours of community service restitution. I'm going to require weekly sober support meetings. And there's to be an hour deducted for every sober support meeting completed from his community service hours. Probation, is there anything else?
No.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. Here's the thing. I'm not going to be here if you come back on a motion to revoke. You need to realize that you're looking at 3 years in the prison if you come back on a motion to revoke. You understand?
Yes, ma'am.
Make sure you stay in contact with probation.
Will, ma'am.
All right. I have been accused of being too lenient by some. So I'm telling you, I'm not going to be here. So make sure you follow through. You understand?
Yes, ma'am.
All right. Thank you.
Thank you so much.
Just one thing, Your Honor,